Check, check. Mic check. Okay.
The only thing you can do. How are you? Good to see you. How are you? I have not forgotten about you, I promise.
I get the inside all the time about how rude people are.
It's not normal. It's not normal.
John, how are you? Congratulations.
Mic check, mic check. Is that good? Okay.
It's just a good thing. Good. I don't know. Is Mr. Perry here? No.
All right, that's
Oh my God.
hot.
I'm sorry to hear that. Yeah. Thanks, John.
Good morning.
Morning.
I'll call the meeting to order. Welcome. Thank you for being here, and thank you for your interest in the board's work. We'll begin with a pledge of allegiance. Please stand. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mr. Classy, could you give us a safety briefing, please?
Thank you, Mr. Chairman and members of the board. We'd like to start this meeting the way we do with a safety announcement for all of our guests and visitors. I'd like to let everyone know that we are on the second floor. As a reminder, we don't typically have meetings on the second floor of a building. So we are on the second floor. In the need for an evacuation, please use the staircase. Try to exit in an orderly fashion and avoid the elevators. For those of you sitting up here in the front, there is an exit door right behind that screen, so keep that in mind. And there's another one here, and you can always use the exit door that's not identified, but where you entered from to reach the main staircase. We do have a first aid kit and an AED nearby if necessary. Thank you very much, and enjoy the meeting.
Thank you very much. And now we'll go to public comments. And the first is an attorney named Jeff Aaron. And just a little bit of background here. I actually invited Mr. Aaron to speak here today. He called me on Monday and advised me about some information that was new to me relating to a widow of one of our firefighters. And then I received a letter from him this morning, but after receiving his call on Monday, I asked our general counsel to do some background work, and I believe he will have an update for Mr. Aaron concerning his presentation. And as I've indicated before, during public comments, the board doesn't answer any questions and typically doesn't comment, but since I have invited Mr. Aaron, I anticipate that we will have some comments from the board, and we will certainly have a response from our general counsel and perhaps some questions. So, Mr. Aaron, just state your full name for the record and tell us who you represent. I know you're doing it on a pro bono basis, and we really appreciate that. But please state your name for the record.
Thank you, Mr. Chairman. My name is Jeff Aaron. I'm an attorney at Gray Robinson, and I'm here representing Miss Leslie Dormany, who is the surviving spouse and widow of fallen firefighter Lieutenant Jim Dormany. As many of you know, Jim Dormany, Lieutenant Dormany, had worked for Reedy Creek for 18 years before he fell in the line of duty in May of 2017. His wife, my client, Miss Dormany, has been waiting for 6 years for some relief from the Public Safety Officers Benefit Program, which is administered by the Department of Justice, and that's a program that would pay benefits to fallen firefighters and other public safety officers. For 6 years, Ms. Dormany has been waiting for word from the Department of Justice, and they're unable to respond to her because the application is incomplete. The PSOB application is 2 parts. Part A is a portion that the claimant fills out. In this case, that's Ms. Dormany. She filled that out in 2017. And Part B is a portion that the officer's agency must fill out. In this case, it had been Reedy Creek for 6 years. For reasons unknown to me, the Reedy Creek had been unwilling to cooperate with the PSOB office and refused to fill out that form. It is literally a form. The lion's share of this document is contact information. Some basic multiple choice, questions on the method, on the relief requested and the cause of death, if it's even known. Once the DOJ gets this form, then they will be able to complete a thorough review of Ms. Dormany's application and render a final determination. I know this with certainty because I've been in contact with a gentleman by the name of Michael Jenkins, who is the he is the benefits specialist assigned to this claim. Mr. Jenkins has expressed a great desire to help Ms. Dormany and make sure that this application is complete, had been in touch with Reedy Creek lawyers in the past who instructed him that they would not fill out the form, and he was shocked to hear that. It's rare that an agency doesn't support a fallen firefighter. But he remains willing, Mr. Jenkins remains willing to communicate directly with the Reedy Creek District, with the Central Florida Tourism Oversight District, and help in any way possible to complete this form and submit it so that Ms. Dormany can have a final determination. I've got copies of my letter here with me, along with my email communications with Mr. Jenkins, so everyone can have his contact information. You can email him, call him directly, he even offered his cell phone. And so I'm here today just simply asking that this board, who can and should do better than Reedy Creek did for 6 years, direct your executive director or your attorneys, whoever the appropriate person is, to complete this Part B application and submit it to the DOJ. That's all we're asking. I'm happy to answer any questions, but that's all I have.
Well, Mr. Aaron, thank you for your comments. We will have some information here in a moment from our general counsel, but I anticipate that some of my board members will have some comments, and I'd first ask Supervisor Ongst, who's been very interested, involved, and this issue's been very near and dear to his heart. So, Supervisor?
Thank you, Mr. Chair, and thank you, Attorney Aaron. First off, I greatly appreciate your representation of Mrs. Dormady. This is an issue that was brought to my attention very early on in the process of the transition between the boards, and it was one of the main issues along with the union contract that I know that all of us have undertaken. I guess I'll turn it over to Dan to maybe update us on what he's found out about the Form B. But I don't see any reason, and I have investigated it, and Mr. Classy has provided me with emails back and forth between the district, the old district, and DOJ. I fully understand the issue from a legal context. I understand the position that the district previously took, but I am more than willing, and in fact, from my perspective, as one of 5 directing the district to move on from that position and to fill out the Form B. My understanding, if to distill it, is that our refusal to fill out the Form B kicked it into a different, more bureaucratic process. But Mr. Langley, do you have any other information on that? All we have to do is fill out the form, is that right?
Excuse me, there's a Form B that needs to be completed. I went ahead and reached out to the district's existing labor and employment lawyer to get access to the file to review everything, and that's already in process. The files were transmitted last night to the Labor Council, and he's reviewed about a third of that file, and thinks as of the end of the day, he'll be able to make a recommendation to the staff to move forward with completing that form based on that information. That's assuming there's not something else in that file that would reverse that position from a legal standpoint. But essentially, we do think at this time it will be possible to complete that form in a way that would not be a mischaracterization of anything, and we can provide that to DOJ probably as early as next week. I would like the board's direction to move forward in that regard with flexibility pending review, completion of review by legal counsel. We got on this as quick as we could, and we're still within 24 hours of completing that review. But I would ask for your direction to do that. If any other questions from the board?
Are there any further comments from the board?
I would comment that I, like Brian and yourself, Mr. Chair, had some interest in this, and I've taken some time with Mr. Langley to discuss it. I'm happy to, I know we sometimes need to either just give direction now or continue to work with staff to get something done. I'm happy to volunteer to help Mr. Langley finish whatever needs to be done in the next day or two. I think it's appropriate for a lawyer to help, since the Department of Justice has a lawyer, and obviously the parties represented, and I think we can get that done very quickly. And I'm happy to continue to assist in that, or let someone else take the laboring war.
Well, thank you for that. Bridget, do you have any
No,
comments?
I would echo those comments. I think that what I don't want to see is it further delayed, but I understand and respect the due diligence. So whatever authority we can give today, so that that is not going to be further stuck in any kind of paperwork or bureaucracy, but obviously doing the proper due diligence. So thank you for coming forward. Thank you, Supervisor Holmes, for also your continuous work on this. But and to the Dormady family, I'm sorry that it has taken this long, but I'm very eager to see us resolve this immediately.
And thank you, and Mr. Langley, do you need a formal motion?
That's the board's prerogative. I wouldn't, well, I would ask you for direction, either by consensus. It sounds like I have consensus to move forward in the direction that we're already moving forward with. So I don't think you need to take action, but if you want to, I welcome it.
I can, Mr. Chair, if the chair would like to entertain a motion.
Sure.
A motion to, with the commission's consent, to continue working with Mr. Langley to wrap up this process and get that form submitted as soon as we reasonably can get it submitted.
Any further discussion? Any opposition? Let the record reflect that it passes unanimously. Thank you again, Mr. Aaron, and thank you for your good work.
My pleasure, thank you.
Thank you, Mr. Aaron.
Speaker number 2, please state your full name, and if you're here in a representative capacity, please tell us who you're representing.
Thank you, Mr. Chair. My name is Stephen Schussler. I represent Rainforest Cafe, T-Rex, Yak and Yeti and the Boathouse at Disney. First, I'd like to say thank you for allowing us to speak and share some of our concerns. And I want to thank you for keeping the state open during COVID. It made a big difference for all of us, and we were able to stay in business. Our employees at all of our places, and my partner Steve Lombardo will be speaking next, and I might yield some of my time to him if that's okay with you. He's got more facts than I do. I'm very passionate about what I've created. I have laboratories in Minneapolis, Minnesota, where I create my concepts, and it's taken me 5 years for each concept to present to the Walt Disney World Company, to get accepted, to raise the money, and find the right real estate for us. So my history has been all Rainforest Cafe, T-Rex, Yak and Yeti, and the Boathouse. And we're talking over 30 years that we have invested in all of our staff and employees. Some of the proposed changes will affect every single one of them. A lot of those people are just getting by paying their insurance for cars. Some of them take buses to work. And I think every one of them have expressed concerns over what's happening with Reedy Creek. I worked really hard to develop relationships with everybody at Reedy Creek and everybody at Walt Disney World. And we're starting over. And I hope that we're starting over with a group that feels concerns for all the people that are not affected and affected by all the decisions that you make. We work hard. Some people work double shifts. Everyone's lives are on the line. And I don't know if everyone is as passionate as I am, and they've devoted as much time and concern to the operations. But I can tell you that it would be great to have an advisory board with operating participants and with other people that are affected, so that you could hear some of our concerns during all your meetings. It would be great to be an insider instead of an outsider. And I would volunteer to be part of that in any way that we can. We obviously, with all the number of restaurants that we have and I'm affiliated with, represent a great deal of employees and a great deal of time that I've invested. With that, I'll yield the rest of my time to Mr. Lombardo, who has some more facts and a better indication of tax consequences and other issues. And again, welcome, and I thank you for allowing us to speak.
Well, thank you for your comments. And of course, small businesses are the backbones of America. And thank you for being one of those members of the small business group.
Thank you, sir.
Thank you, Mr. Chairman. My name is Steve Lombardo. I'm the CEO of the Gibson's Restaurant Group, and I'm partners with Mr. Schussler in the Boathouse restaurant at Disney Springs. The Boathouse is one of the most popular restaurants at Disney Springs. We do employ 492 people there. We are a tenant of Disney's. We are not Disney. Last year, our restaurant paid between sales tax, rent tax, real estate tax, and property taxes, something in the neighborhood of $3.9 million. Restaurants were hit very hard by the pandemic, and as Steve said, we are very grateful to the state of Florida for keeping us open during that time period. I have 12 restaurants in the Chicago area, and they were facing an existential crisis during that time period, and we didn't have that here, and again, we're very grateful for that. The restaurant business is run on very tight margins. We have costs that have increased dramatically over the last year. Inflation has hit us pretty hard, and the discussion of additional taxes, additional utilities has been very concerning for us. And I want you to just please understand that when you make these decisions, that it impacts far more than just Disney. Thank you very much.
Well, thank you for your comments and your entrepreneurship, and I think you've heard from this board before that one of the goals and the reasons we were appointed is to make sure that this district functions better for more people. And we are very sensitive to the concerns and issues that impact small businesses like yours. But maybe I shouldn't call it a small business with the number of restaurants that you've been able to create. It's very impressive. But we will have open ears to, as your partner indicated, opportunities to hear comments from you all. One of the things that we've heard as a board is that the last board was tone deaf to ideas from employees and perhaps small businesses. But one of the changes you will see from this board is that we will have systems in place for you so we can hear your ideas and we can indeed make this more prosperous for more people and more businesses like yours. So thank you very much for the comments. And next, number 4, please state your name, and if you're here in a representative capacity, please tell us who you represent.
Sure. Good morning. My name is Melissa Gibson, and I represent businesses with my husband located in Disney Springs. So I would like to yield my time to Mark, with your permission, so he can speak on our behalf.
Of course.
Thank you.
Good morning. Thank you, Mr. Chairman. I'm going to largely echo the comments of Steve and Steve, but I'm going to be a little more wordy than they are. Sorry about that. Thank you for the opportunity to speak. My name is Mark Gibson. I apologize. I'm going to read a large portion of my thoughts, but with a limited time and the importance of the topics, I just want to try to get it right. I've lived in Florida for more than 30 years. My home has been in Orange County since 1999. I'm married to Melissa, who you just met. We have 2 children, Grace and Jack. Grace is a freshman at Furman University, and Jack is a junior at high school here in Orlando. I'm a registered independent, and I voted for the governor 2 times. My business partner, Guy Revel, from Tampa, and I graduated from Wake Forest too many years ago, and then had the good fortune to move down to Florida in 1990. Since then, we've operated hospitality businesses all over this great state, from Key West to Lake Wales, from South Miami to Winter Park, and from Fort Lauderdale to Tampa. In Orlando specifically, at Disney Springs, we've operated for more than 10 years. Excuse me. We own and operate 3 concepts: Splitsville Luxury Lanes, Homecoming Florida Kitchen, and Everglazed Donuts and Cold Brew. If you haven't been there, I really would love to have you guys come see us. I'm here today to express my concern, as the prior gentleman, just regarding the ongoing tension between the board, the state, and Disney. The focus has been on Disney as the corporation, but as you've heard, the parks, hotels, most of Disney Springs, and other ancillary uses are largely made up of regular, real people in Florida, small businesses, small to medium-sized businesses, my friends back there. This dispute's continued for more than a year. There's already been a lot of negative publicity that we have to deal with guests and with customers, and ultimately we're just concerned there's going to be repercussions to our restaurants. Our businesses employ over 450 people in the combined Disney operations. These people work hard for 3 different small businesses. They don't work for Disney. They're talented and they cross every demographic. Now I just want to take a quick step back before we go forward. As we all know, over 36 months ago, we were all shut down, all of our business across Florida as a result of the pandemic. Those were really dark times for us and for everybody else. But when I look back on that period, I personally believe we survived and rebounded so quickly based on 2 primary factors: the leadership of Governor DeSantis and his extended team, and the patience and long-term perspective of Disney. Governor DeSantis was responsible for keeping the state open for business, instrumental in encouraging the wheels of industry to keep moving, and we feel his leadership was much more effective than any other governor across the country. We also operate at Splitsville in California, so we know firsthand the pain of lockdowns. Splitsville, Orlando was closed for 10 to 12 weeks, while our Splitsville in California was closed for more than a year. So we get it, probably more than most companies, and we appreciate the ability to operate in Florida. We just don't want to lose it. On the Disney side, we couldn't have asked for a better partner during those difficult times. Disney was a very equitable landlord. Also, which at times gets forgotten in some of the discussions, Disney hosted the NBA playoffs in the bubble, of which we were a small part. It was early in the pandemic. It was very important to show that business and sports could continue, and it helped restore some semblance of normalcy. However, what was not seen were the countless meetings where people from our team, from other OPs, coordinate with Disney management to deal with these historically daily issues on how to strategize on some level of keeping operations open while also keeping guests safe. Disney and its operating participants worked as very good teams during this whole pandemic. You find out a lot about people during times of adversity. Governor Stannis led, Florida led, and Disney led. I know this board is charged with making long-term decisions with the district and to oversee aspects of the Disney team. We have found our experience with Disney to be very reasonable. They're committed to excellence, guest satisfaction, and best practices. They invest in their properties, continue and innovate, and keep their parks in Disney Springs clean, safe, and relevant. I can't help but think that Disney's ongoing investment in innovation might suffer with increased taxes, more regulation, and potential other actions. There should be a great working partnership between this board and Disney. And now that we're all getting back on track, I'm sure that no one wants anything that would stifle small business again. We also pay a very large amount of taxes. Property tax and sales tax was in excess of $3 million in 2022. We're very happy to pay it, and we don't like the alternative. In closing, over the past 14 years, I've had the opportunity to work with with much of Disney senior leadership all the way up to Mr. Iger. They work hard, they care about their people, both cast and guests, and they are focused on a long-term vision. Similarly, I've watched our governor and his team guide the state through unprecedented times. Their leadership and fortitude during the pandemic, as well as the ongoing stewardship of Florida, is in my opinion, unparalleled. Disney, the state of Florida, and this board could be a powerful coalition with its talent and resources. We should do great things. Therefore, I urge the executive team at the executive team at Disney, the governor's office, and this board to try to find a resolution that works for everyone. Let's get the two sides talking. Let's get back to business. God bless Florida. God bless the United States. Thank you for your time.
So, Mr. Gibson, thank you very much for your comments. And the balance of what you presented makes a whole lot of sense. And you'll hear later in the meeting a number of issues that address your concerns. And like I said earlier, we're here to serve everyone in the district, and particularly small businesses like yours. And I didn't know I was going to meet a fellow Demon Deacon.
All right.
I am too.
I'd tell you when I graduated, but that would give away my age.
And your partner guy is actually a neighbor of mine in Tampa.
Oh, really?
Yes, sir.
Oh, well, good to hear it. He's actually in California dealing with some stress out there, but I got elected to speak. He would not have been able to stay under 6 minutes, so it's probably fortunate he got me.
Well, thank you. This board will take all of your comments to heart, I can assure you.
Fantastic. We really appreciate it. Thank
Yes,
you again.
sir. Number 6, please state your name, and if you're here in a representative capacity, please tell us who you represent.
Good morning, everybody. My wife and I are going to go consecutively 6 and 7. My name is George Miliotis. This is my wife, Leanne Miliotis. We run Wine Bar George at Disney Springs. We are the essence of a small business. We're family-owned. It's the only operation that we have. Both my wife and I were born and raised here in Central Florida. Our families, both before us, owned small businesses. We enjoy paying our taxes. Maybe not enjoy, but we vote, and we enjoy being part of the fabric of the Central Florida community for a long, long time. Our wine bar has been open about 5 years. It's been a happy run for us in many ways. We've gotten great accolades like, are we the best wine bar in the country? And we've won awards like we have the best wine list in the world. It's all great, but what really, really makes a difference, and the only thing that my wife and I really care about, are the 90 families that are employed by our restaurant. Those people come in every day, work hard, and make a living, and they make a good living, and we want to continue to help them make that really, really good living. You may ask, why am I telling this story? The only thing that I want to say is any change in our business climate directly affects those 90 people who are trying to put their kids through school, trying to pay off cars, mortgages, all those type of things. We know a little bit about being Demon Deacons also, I want to say, as our daughter graduated from Wake Forest also, so it's all good. But just please remember that anything that we change affects those 90 people, and that's what we most care about. I'll cede the rest of my time to my wife, Leanne.
Thank you for your comments.
Thank you.
As George mentioned, I was born and raised in Orlando, born in the 60s. My father was also born in Orlando in 1930. So we have spent many, many years in this community. Given that we've spent so many years here, I am very proud of my hometown, and I'm proud to be a Floridian as well. I never traveled that far, just up to the University of Florida, same as my father. I'm very proud of Central Florida. We've seen so many things change in the many, many years that I've lived here, but one of the things that remains the same is how beautiful our Central Florida area is, and the city of Orlando. It's a great place for families to visit, it's a great place for families to live, and it provides so many amazing job opportunities. All these many years I was a practicing CPA in Orlando, and over the last 5 years I've spent taking my expertise to our business, and I ran all the financial and human resource part of Wine Bar George. We've been open, as my husband said, coming up on the 5-year mark, but I can honestly say that it has been the hardest, craziest 5 years of our life. It has been a labor of love from the beginning, and we work tirelessly day in and day out to make it a great place for our employees to come to work and for guests to visit. It is our only location, and we were maybe open just not even 2 years before the pandemic, COVID landed at our doorstep, closed our doors, and we've literally spent the last 3 years trying to recover from the impacts of COVID, as well as just what ensued after with this current economic climate that we find ourselves in. We have, of course, everyone knows, high food costs, high labor costs. Some of our labor costs have increased 25 to 30% with certain people, certain functions within our restaurant than what they were before COVID. So it's been interesting to navigate, hard to find people to come fix our equipment, very costly to come have people fix our equipment. So we're in this constant battle of, can we raise prices to help cover some of these costs that we've had to incur? And we have, and we do, and we're at the point where we've raised our costs to the most that it can be. So any additional costs at this point, we're hoping and praying are going to level out. We just need a leveling out of costs. We are hoping that any type of initiative that you're considering, if it's to raise taxes, if it's to change the operating costs of the property, or if it makes it more costly and difficult for our team to get to work, that will have a significant impact, a financial impact on our business, as well as to our employees and their standard of living. So we appreciate your time hearing our concerns. We hope that the board can get together and maybe come up with some cost savings initiatives. That would be most appreciated, and thank you for your time and consideration today.
Well, thank you also for your comments. It's a real joy for me to hear from so many small businesses. I have a small business, and it too is a family business. Yes. And so I know how challenging it can be, and I know that, as your husband said, that your employees are like your family, so it's one big family. And one of the things that I don't know if you were at the last meeting that we're looking at is that Disney's filed 90 lawsuits contesting their ad valorem taxes. And one of the things that the district was not previously doing is taking any affirmative action in those cases. They were neutral, okay? And so that's one of the things that we're going to reevaluate, okay? And that what may be an opportunity for us to raise the revenues that I spoke at the last meeting, okay, relative to Disney's actions. So I wanted you to be aware of that if you weren't at the last meeting.
Thank you.
Excellent, thank you.
Thank you all again. Speaker number 8. Please state your name for the record, and if you're here in a representative capacity, please tell us who you represent.
Hi, my name is Jacob Henninger, and I represent Basin. Retail Concepts of Minnesota is our full name, and we're a small family business here too, and I yield the rest of my time to my mom, the president of our company.
Awesome.
Boy, mom's pride. I don't know why I'm crying. But as Jacob stated, we represent Retail Concepts of Minnesota. And like Mr. Schuschler, we got our start at the Mall of America in Minnesota and in 1992. And I'm Shauna Henninger, my husband and I opened this, and we're a small business. We're a small family-owned business. We started on carts in Mall of America selling refrigerator magnets and keychains. And we've expanded, and now we own Basin at Disney Springs, Basin White at the Grand Floridian, and Crown and Crest, soon to be Rose and Crest, at Epcot in the England Pavilion. And as the president and one of the owners, we have 89 employees, all at the Walt Disney World. Just sort of a short thing, we've closed all of our other businesses that are not in Florida because we love the climate, the business climate that Florida has. We love living in Florida. Florida's amazing. And I appreciate you guys and the job that you are doing in listening to my comments today, but I am concerned, as all of these other small businesses are. Small businesses we don't have stocks and people and investors to buoy us up. So these proposed regulations and taxes could negatively impact our business and these small businesses. And not only do we support our 89, and I wanted to give you an accurate count, 89 employees that are all in Florida, but also supports many of our suppliers throughout Florida and their families. And many of our suppliers are small, family-owned businesses. And so we're worried, what happens if the taxes and the regulations in this district hurt my business? What happens to my business, my family, my employees? And what happens to companies like mine that partner with Disney? Being a tenant in a lot of other retail environments, I can honestly say Disney has been the best landlord and partner we have ever worked with. And I won't name the other ones we have worked with, but they are giant multinational stock exchange companies. And if we're talking about, if you do something that affects us, thousands of Central Florida residents will suffer. It's sort of like trickle-down economics. And let me offer an example of one of the things that is concerning me. Recently, I read that this board was considering imposing tolls on the roads that lead to Disney theme parks. My employees would not be able to afford to continue to work for me with such tolls, or I'd have to pay them considerably more to keep them from leaving. And at this point, increased labor costs would put an unfair burden on our business that other retailers outside of Disney don't have to pay, might not have to bear. And it could cripple our business to the point of shutting our doors, like we have had to in several other states. I'm grateful to the state of Florida and its business-friendly environment. I echo the sentiments that we appreciate the partnership of Disney and the state of Florida in getting us open so quickly during the pandemic. Just so you know, we are concerned about our employees enough that out of our pocket, we paid our employees' wages, all of theirs, for the first 6 weeks after the pandemic. We are not a business that takes advantage of its people. We care for all of our employees. And unfortunately, as a small business, we have been hurt by COVID. We have been hurt by inflation. Just as been mentioned, our costs are horrible. Now we're staring at a recession. These are hard times for small businesses. So in closing, I ask you to please, please remember me, my family, my 89 employees,
my fellow small business owners, my suppliers, and remember that taxes and regulations matter. And they will affect all of our businesses and all the businesses that operate within this district. And I really appreciate your time, and thank you for listening.
Well, thank you for your comments, and thank you for your family story and your concerns. And what I can assure you is that this board hears you loud and clear, and that we're very sensitive to the prosperity of businesses, family businesses like yours and the others that we've heard from. I mean, you all are the backbone of America, and you all are the backbone of the district. And so I promise you, we hear you loud and clear.
Thank you so much.
Yes, ma'am. Number 9, speaker 9.
I think they were
Yeah,
together.
you're right. Speaker 10. Please state your name, and if you're here in a representative capacity, please tell us who you represent, sir.
Good morning, Chairman and members of the board. I'm Richard Debler. I'm the CEO of Palmas Restaurant Group. I operate 14 locations in Walt Disney World. We have over 700 team members. For the last 40 years, I've been a contractor in the Disney property in different roles. I was born in Mexico City. My family, I grew up in Mexico City. My family started the business in 1963, opened a restaurant in Mexico City. My father, after the Second World War, came down to Mexico and with my mother, and they started the business in 1963. And fortunately, it was a very successful restaurant in Mexico City. And in 1982, the Disney organization approached us and wanted us to participate in the opening of Epcot. And obviously, at that age, I had already opened my first restaurant at age 21, and by age 23, I was already enrolled coming to work here in Florida in 1982. So I'm a little bit of the, I hope I don't look like it, but I'm one of the oldest participants here that have been around this property. So, since then, I've been operating in different areas. I run a hotel, the food and beverage for a resort for Disney, have a restaurant in Disney Springs, and the Mexican Pavilion at Epcot. We have, I want to obviously echo everything that has been said. I mean, there's not much, it's difficult for me to add a lot to what already has been said. Everybody has really done a great job of presenting our concerns as a small or medium businesses operating in this property. It was a tough recovery, coming from the pandemic, and like it was said before, the efforts of the governor and Disney to keep us open was amazing, and that's what most of us were able to stay alive and keep our businesses operational. But at the same time, we still have huge challenges like they were mentioning. We have very high labor inflation and cost of goods, disruptive supply lines. So even so, things have recovered to a certain level, but we still have a lot of challenges in our plate. The other thing, operating in Disney for so long and in the environment and with Reedy Creek, it's not cheap to operate here. It's very expensive. Construction is very expensive. The construction and review process is slow. But I don't want to take any more time of your time, but I definitely think there's a great opportunity to bring back the collaboration between the governor and Walt Disney World to, again, give us another boost and hopefully I'll be around for another maybe 20 years at least. Thank you for your time. Thank you.
Well, thank you for your comments and your entrepreneurship. And in addition to small businesses, first-generation immigrants are the backbone of America. And so thank you for coming to this country and being a great American. Number 11, please state your name, and if you're here in a representative capacity, please, we recognize you, so we know who you are.
Yes, sir. Good morning, Mr. Chairman.
Good
Mike,
morning.
Bridget, Brian, pleasure to see you guys all this morning. My name is John Shirey. I'm here representing the Reedy Creek Professional Firefighters. And I just came here today to give you a quick update on two very important issues the firefighters brought to your attention almost from day one when you guys took your positions here at the district. The first one is going to be in regards to our fallen brother, Jim Dorminey. Jim passed away after working a 24-hour shift back in May of 2017. And for the past 6 years, we had been in a battle with the previously appointed Disney's appointed Board of Supervisors just to obtain those federal death benefits. This did not cost the district a dime, but as you guys have already spoken and Mr. Aaron also addressed, we have had no movement forward. I can't tell you how much that I appreciate the actions taken by the board today. I mean, what you've done will finally put to rest an issue that is near and dear to every single one of my members, and it's going to secure the benefits that the Dorminey family so greatly deserves. The second issue that I wanted to give you an update about was about the 4-year expired contract between the firefighters and the district. For the past 4 years, we have had zero progress forward. We're basically at a day one point when you guys came into your positions. I am beyond thrilled to announce to you guys and to everybody here today that as of yesterday, we have a full tentative agreement that our membership is getting ready to vote on, and it should be here and ready for your consideration at your May Board of Supervisors meeting. With the leadership and direction that you guys have provided, I mean, you've truly created a life-changing benefit for our members and, of course, for the Dorminey family. And so I just wanted to close with this. The actions that were taken by our governor, Ron DeSantis, along with the state legislature that put you all in these positions, was probably one of the single best things that could have happened to me and my members. Again, what you've done is you've created an environment that is really just a life-changing and a career-altering event. And I just want to thank you guys all from the bottom of my heart. You guys have my respect, and I look forward to working with you guys for all the years to come. Thank you.
Well, thank you for your comments, your kind words, and most importantly, thank you for your service to the district.
Thanks, John.
Number 12. Speaker number 12. Please state your name, and if you're here in a representative capacity, tell us who you represent, please.
Hi, good morning, board. My name is Deborah McDonald. I am just a resident of a community and surrounding area. I live in Osceola County. I did not grow up here. I'm not from here. Have had a small business here and worked here, but I'm really just coming to speak to you from my heart. And I do hate speaking, so I apologize if this is jumbled. But again, I live in a surrounding community of Osceola County, which has approximately 400,000 residents. My father was an Air Force colonel. I did not grow up here. We moved all over and lived and traveled over most of the world. I had never had a home for more than 2 or 3 years. When we came to this area, we bought a home, myself and my husband and our 4 children, and we have lived in a little town that Disney built called Celebration for 26 years now. I love our community. Ever since I stepped foot in our community, my purpose was to serve the community, the surrounding area. That's how I was raised. I've spent every day trying to follow in my parents' footsteps of service. Both my parents are buried in Arlington Cemetery in Washington, D.C. I'm afraid of losing our home. Many people in our community are afraid. I will say that uncertainty, fear, and controversy are not good synonyms when you look at the leadership. And I've always respected whatever leaders were in power. I have never lived in a state where I have feared the leadership or what they would do. Reedy Creek was our neighbor, still is our neighbor, Disney our neighbor for the entire time I've lived here, and I will say they have been an incredible neighbor. I'm on many boards in our community, and one of them is Advent Hospital, which is the hospital that you would go to if any of you were injured right at this moment. When we were faced with a pandemic and we didn't have supplies and you couldn't get masks anywhere, we didn't even have enough cleaning supplies, I called on Disney. I just mentioned it, and they were there every step of the way to help not only our community, but anyone that set foot in that hospital. When we had a problem with our schools, way back when, years ago, Osceola County is not known for having a lot of money. Most of it goes to the tourist tax, and we do not have enough for schools or for our healthcare or for first responders or roads, et cetera, you name it, because most of it, again, goes to the tourist tax, which is a whole nother issue. People volunteer, people help their neighbors, people are there for each other. When this issue happened, call it what you may, I call it a feud, it has hurt us. It has hurt us deeply. It's not just between the governor and Disney, it's affecting everyone around him. I know my time is up, but I'd like to say that please keep that in mind, that we live here and have lived here, and this is our home. Thank you.
Well, thank you for your comments, and thank you for speaking from your heart. One of the things that the board has mentioned that's important is we're going to do a regional fiscal impact study. And you mentioned residents like yourself being impacted that don't live in the district. And that's never been done before in terms of analyzing the impact that this district makes on the residents that live around it. And so we're going to broaden our scope to make sure that we're sensitive to neighbors like you, and we very much appreciate your comments and hear them loud and clear. Thank you. Next, that concludes the public comments part of the agenda. There's nothing on the consent agenda. I would note there's 2 items on the information items, a report on permitting and regulations, and then a schedule for proposed budgeting. And we're going to start that, I think, as you heard from our financial advisors at the last meeting, very shortly. Next, as to reports, Mr. Classy, do you have a management report?
Meeting, Board Member Sasso asked that I give a brief summary of the eminent domain authority of the district. So I wasn't going to spend too much time on that, but I want to generally say that the district does have eminent domain authority, which is a legal process by which a governmental entity can compel the acquisition of private property that's necessary for a public purpose. And it provides under the Florida Constitution that the property owner is compensated with full compensation, which could include any damages caused to the remaining property and reimbursement of that property owner's attorney's fees and expert fees as provided by Florida statute chapter 73 and 74. The district generally has the power to exercise eminent domain for any public purpose for which it was constituted. This includes, but is not limited to, the construction, maintenance and operation of roads, utilities, drainage, projects, public buildings, and other public facilities. This power is granted by Section 8 of the Enabling Act that was adopted and signed into law this February. Unless you have any questions for me, I didn't have anything further on this. I do have, of course, comments on the following agenda items.
Supervisor Sasso, do you have any further comments on that?
No questions, no comments, Mr. Chair.
Okay, thank you.
Okay, if we're on the new business 8.1, if you could IT put up my slideshow. development agreement that purported to vest comprehensive plan intensities and densities and uses district-wide within the city limits of those cities. The city councils of Bay Lake and Lake Buena Vista did not hold public hearings on or approve the development agreement that is at issue that we've been talking about for the last couple of meetings. That makes the development agreement void, ab initio. That's a fatal flaw. Each of those cities had to also conduct notice public hearings and approve this development agreement because the development agreement purports to vest densities and intensities uses and grant transfer of development rights for all properties that Disney owns. And those properties include not just what's in unincorporated areas that the district has authority over, but also the incorporated areas contained within those cities. And as you can see, I've included a snapshot of the parties to the DA, and it's solely Walt Disney Parks and Resorts USA, Inc., and Reedy Creek Improvement District. The cities are not parties to this agreement. Also, prior, as I said, because the district didn't have the authority to district-wide do comprehensive planning, land development regs within the city limits, that's why you'll see that the district and the cities in the past have adopted joint comprehensive plans and adopted land development codes verbatim and tandem. That's because the district could not act alone on those things. So because one entity essentially controlled all three jurisdictions, the three jurisdictions worked together in the past to adopt the same comprehensive plan, the same land development regulations. Now, people might be confused by this, thinking, well, doesn't the district deal with applications for development? Well, they do, but there's an interlocal agreement between the district and the cities that creates a situation where essentially the district staff functions as the city's staffs as well. But when those district employees are operating in that manner, they're actually exercising the authority of the cities. Now, if you recall from the prior meeting, there was actually no staff review of the development agreement. That went straight from a lawyer of Disney to a lawyer also of Disney, but ostensibly the district, and then straight to the board. So there wasn't even the staff level of the cities, the staff of the district acting in their capacity as city staff members either reviewing this document. The bottom line is that a development agreement has to be approved by the governing body of a jurisdiction, and that didn't happen from the cities that have jurisdiction. Now, what's the law say now? In February 27, 2023, the act that constitutes this board, the Central Florida Tourism Oversight District, changes that relationship completely. The district now has the authority district-wide for comprehensive planning, zoning, land development regulations, environmental regulations. They have it all. And not only do they have it all, they must exercise that authority in the city limits. So there's no longer jurisdiction of the cities. There's no longer separate jurisdictions. The district has jurisdiction within the city limits of those two cities to exercise these powers. And not only do they have the right, they must do it pursuant to, as you can see here, the must exercise its authority on these matters within the city limits of the cities in the district. And the cities now, their only authority is to, if they wish to exercise it, is to implement more stringent regulations than the district may implement and enforce. All right, I also wanted to give you a little timeline. I'm not going to go through this in detail, but of course this is a public record and that you all can take this away from today. But I think it's important to have a perspective of what happened, what transpired before February 8th, 2023, and the Reedy Creek Board of Supervisors approval of the development agreement and the restricted covenants. There was a process to start what they call appraisal evaluation report comprehensive plan amendment process that started all the way back in June of 2017. The first reading, now I'm going to tell you about this. The comprehensive planning amendment process is a process that starts with usually staff puts together a proposed amendment, and then you got to have a local planning agency review and give a recommendation to the governing body. The governing body has a first reading and a public hearing to consider those recommendations of the staff and the local planning agency. And if at the first reading, that comprehensive plan amendment is approved on first reading, that comprehensive plan amendment is transmitted to the Department of Economic Opportunity for review and comment. The Department of Economic Opportunity's review and comment is extremely limited. They have, after some changes in the law over a decade ago, very little authority to comment on comprehensive plan amendments. Once the Department of Economic Opportunity grants or gives comments on a comprehensive plan amendment, the local governing body is supposed to conduct the second reading and public hearing on that comprehensive plan amendment within 180 days. Okay. And then at that point, there's supposed to be a public hearing and final adoption or rejection of the comprehensive plan amendment. Now, so the first hearing of the comprehensive plan amendment that concluded in May of 2022 started on first reading in November of 2018, almost 4 years ago. So in the timeline, you'll see that the City of Bay Lake, the City of Lake Buena Vista, and the Reedy Creek Board of Supervisors all adopt on first reading their separate ordinances adopting or transmitting and verbatim the same comprehensive plan amendment. In this comprehensive plan amendment, there were no changes proposed to the densities of uses, meaning there were no proposed new parks, new hotels, none of that. No new retail, no new office space, no changes to permitted uses. And I can show you what was actually proposed. It was essentially a proposal that was cleaning up outdated references to the state law, and it was also, sorry, I'm having some issues with my mouse here. Okay, this is a letter that is transmitted to the DEO, Department of Economic Opportunity. If you can see on this side over here, it's essentially summarizing the purpose, the original purpose of the comprehensive plan amendment that was transmitted in November 2018. The purpose of the comprehensive plan amendment is to fix or update our comprehensive plan to change references with regard to state law on our transportation element, update outdated references to the Florida Administrative Code that were changed since the last comprehensive plan update, revise the housing element and infrastructure element, potable water sub-element, revise certain dates to meet current conditions, and to update the future land use map to reflect the de-annexation of property that occurred. You notice what's not in here. There's nothing about we're adding a 10-year additional plan for new parks and a lot of new hotels or changing the uses. There's nothing like that in here. This is the first reading of the comprehensive plan amendment that was finalized last year. Okay. So, let me go back. I wanted to show you also in the letter. You see right here, it says that the district was intending to actually complete its adoption of these comp plan amendments in April 2019. Okay, that didn't happen in April 2019. I'm not fully understanding the reason why it took so long, but after 3.5 years, there was some renewed interest in comprehensive plan amendment that was transmitted a long time ago. And it just so happens to be around the same time the legislature passed Senate Bill 4-C that would have dissolved the district in the summer of this year. Within a month of that law, we have the district and the two cities attempting to adopt the second reading and public hearing, via second reading and public hearing, a comprehensive plan amendment that they started 3.5 years earlier. What's interesting about these ordinances is that, and I'll show you an example. I think because there was a lot of lack of transparency, the agenda packages themselves for the district and the cities failed to contain the proposed changes to the comprehensive plan amendment attached to the ordinance, even in the version that the board members and the city council members themselves received. I'm going to take you to May 25th, 2022. This is the Reedy Creek Board of Supervisors agenda. Scroll down. This is the comprehensive plan amendment, second reading, 3.5 years later after they did their first reading, which is unusual because you're supposed to do your second reading 180 days after you get comments from DEO. Scroll down to what are they adopting? Section 3. They're adopting ear-based amendments that amends these elements of the comp plan. In the text shown that's being amended is shown with strike-through underlines. But the thing is, there are no strike-through and underlines in the agenda packet. So this isn't actually doing anything. This doesn't adopt anything. You also will look, what is the purpose? What is the purpose? Oh, I'm sorry. I'm not. For some reason, it's not displaying my PDFs. How do I display the PDFs? Oh. Sorry. Okay, thank you. So this is the ordinance in the agenda packet. This is the second reading and adoption hearing. This section 3 is what the amendment is supposed to be doing, and it essentially says that what is attached is what we're amending in the comprehensive plan. And there's supposed to be a strike-through underlined version showing the existing comprehensive plan with the changes being made. And this document, this ordinance resolution, has no strike-through underline. This is the official agenda packet that the Board of Supervisors was considering. It also states the purpose of this comprehensive plan amendment. What is missing from the purpose in applicability section is all the things that Disney was attempting to ram through with the comprehensive plan amendment in May 2022. There's no mention of we're updating the 10-year capital improvement plan to require the district to do all these new projects. There's nothing in here about increasing densities and intensities district-wide. There's nothing about changing the list of permitted uses. This language is exactly the same as what was the original purpose, which was minor updates to adjust for revisions in the Florida Administrative Code, some minor changes in the law, and to do a de-annexation. The cities had the same language in their comp plan amendment. The cities also did not have in their packages, oops, I'm sorry, bear with me here, I'm scrolling through multiple documents. The cities, this is Bay Lake, May 2022. Same thing, they were having a public hearing to consider the comprehensive plan amendment on second reading and adoption. This is the ordinance of the city of Bay Lake. Scroll through, again, they have in here in section 3 that what they're adopting is shown on Exhibit A. Exhibit A. Okay, where's Exhibit A? There's no Exhibit A. So this means that the city adopted something that has no consequence, because that Exhibit A is what the adoption is supposed to be. Again, I go back to section 4. Again, it talks about the purpose, and the purpose doesn't say anything about what the real purpose was, which was let's add a bunch of density, intensity, and change the uses. Now, what's interesting about this is, keep in mind that this is May 2022. If the comprehensive plan process would have started at that point in time, they probably wouldn't have been able to get it done before the district either dissolved or the legislature met in session earlier this year to reconstitute the district. So there was a reason that, let's just pick up the second reading and use that as the vehicle to add these new things. It's because if they started over, they wouldn't have time to get it done. Because I'll talk about this later. They also had to do land development code changes to implement those changes to the comprehensive plan. Then they had to do public hearings on a development agreement. All that takes time. So if they would have restarted the process like they should have, legally, they were required to when you change the original purpose of the comprehensive plan amendment and go back to the first reading, they wouldn't have had time. Okay, so the two cities in the district all adopt ordinances without exhibits. So that makes the comprehensive plan amendment non-existent. However, the district and the cities transmitted jointly a letter to DEO claiming that they adopted changes to the comprehensive plan. The DEO takes the local governments at their words that, that they in fact adopted these ordinances correctly. The transmittal letter that was sent to DEO by the district, says, okay, here's what we adopted. We adopted all these things in this document here. It's over 300 pages long. None of that was actually adopted. And one of the things that was in this, of course, is what we've been talking about, is these tables which significantly increase the number of hotels, resorts, the number of retail, restaurant space, office space, theme parks, changing the properties that these uses are allowed on. There was a change to the capital improvements plan. None of that was in the first reading or transmitted as the original intent of the comprehensive plan amendment. Okay, so after the comprehensive plan amendments were purportedly adopted, which they were not, The district and the cities then move on to attempting to adopt land development regulations to implement that new comprehensive plan amendment, which wasn't actually adopted. The district in December of last year conducts the first reading, public hearing on ordinance resolution 637, which increases densities and intensities and changes permitted uses. And then the cities do the same thing in January 11th. Okay, in January 11th, the city council meeting agendas for the land development ordinances have the same defect. There are no exhibits to the ordinances to show the changes that are being made by the Land Development Code ordinance. Apologize. This is the ordinance resolution number 139 for the city of Bay Lake, amending the Land Development Code, supposedly in compliance with the 2032 comprehensive plan that didn't actually get adopted. And you'll see here in section 2, it says the regulations set forth in Exhibit A and adopted hereby shall be known as, etc. But, you know, again, as I said, there is no Exhibit A. This is also true for the other city. There was no Exhibit A, and I don't think I need to go through that. It's a matter of record. These are on this is on the district's website already. These agenda packages show you there was no exhibits to these ordinances. The district conducts the second reading public hearing on January 25th, 2023 of its land development code changes. What's also interesting is the district on the same day also conducts a first reading of the development agreement. Why is that interesting is that the cities haven't even had their second reading and adoption of their land development code yet. And the DA purports to vest the land development code even in those cities, and the cities haven't even adopted the land development code that the development agreement purports to vest. So it's very strange. You're having a public hearing before to say your development agreement is consistent with a regulation that hasn't even been adopted yet. So around this time, also February, HB 9 gets filed in the legislature. It moves forward very quickly. It's passed in February 10th. You can see the scurry of activity that's happening in the cities and the district. You know, we're having meetings at the cities a half an hour from each other to attempting to adopt the land development regulations on the 8th at 8:30 in the morning, 9 o'clock in the morning, in the district at 9:30 in the morning. At 9:30 in the morning, the district then attempts to approve the covenants and restrictions that we've been talking about. And they also conduct the second reading of the development agreement. Was a sort of interesting in the sequence of that February 8th meeting of the district is that the covenant document is approved before the development agreement. The development agreement did not legally exist at the time that the covenants were approved, yet the covenants purport that the development agreement is the consideration for the covenants. So how could something that doesn't exist be consideration? Okay, so I wanted to point out, why is this important? Why am I making a point about ordinances not having exhibits? It's because legally, under Florida law, 166.041, the municipal ordinance adoption statute, it states that no ordinance shall be revised or amended by reference to its title only. Ordinances to revise or amend shall set out in full the revised or amended act or section or subsection or paragraph of a section or subsection. Meaning, you got to show what you're doing. You can't just read the title of an ordinance, have an ordinance that's 2 pages, and fail to include the attachment that shows the strike-through underline. So this is I think this is really common sense. I mean, this isn't just a statute. If you're saying I'm hereby adopting what's on Exhibit A, and there's no Exhibit A, are you doing anything? The answer is no, you're not. You're not doing anything. It's just common sense. Okay, so also the official records of the district, the official resolution book containing the executed and adopted versions of the ordinances resolutions for the comprehensive plan amendment and for the land development code have no exhibits either. So this is not just a situation where, oh, we just forgot to put it in the agenda packet. You forgot to put it in the official records book for the ordinances and resolutions. You didn't forget. You were trying to not be transparent about what you were adopting by not putting in the agenda packet so nobody could see what was really going on, and you had vague titles describing an EAR-based comprehensive plan amendment that started in November 2018 with a completely different intent and purpose, which was to fix some language, outdated language that referenced 9J5 Florida Administrative Code, updated a couple elements, transportation element, and to deal with a de-annexation of property. Not all this other stuff that was purportedly adopted in May. So, all of these tables in the comprehensive plan and the land development code that were purportedly updated in May of 2022 and February and January of this year are not actually adopted into the land development code or the comprehensive plan. They do not exist. So, your development agreement that purports to vest under comprehensive plan amendments and land development codes that don't exist, don't do that. Furthermore, we've already gone through the development agreement, a lot of the flaws, but this is a further flaw. This is a major issue with this whole development agreement and the restricted covenants, and just shows you with the timeline how rushed this all was. And anyway, I wanted to, unless there's any questions, turn it over to former Supreme Court Justice Alan Lawson at this time.
Thank you. Mr. Chairman, members of the board, last week we talked about the fact that this is essentially about what it means to live and work in a country governed by the rule of law. Everyone must play by the same rules. Disney was openly and legally granted unique and special privilege, that privilege of running its own local government for a time. That era has ended. As we now know, Disney worked with the old Disney-controlled district board in its final hours in a sweeping attempt to, without notice, retain control over all of the property in the district so that it could assure that the land Disney owned, as well as the government-owned property and that owned by private citizens, would continue to be tied up, controlled, and used as Disney desired for the next 30 years. We also know that this attempt was not carried out in accordance with Florida law. For that reason, it's invalid. Last week, we highlighted a number of reasons why the development agreement and restrictive covenants produced by the Disney board were void ab initio, of no legal effect from the moment that they were entered. Today, Mr. Langley has highlighted some additional reasons why Disney's attempt to bind the hands of this board in the exercise of its lawful powers has failed. I will very briefly summarize these issues. There are essentially three ways that the old Disney Control Board's actions were unlawful in a general sense. I'm not talking about criminal actions, just a failure to follow the law that applied to those actions, with the result being that the attempted actions were of no legal effect. First, the old board attempted to act without legal authority to act. As you can see here, under Florida's Constitution, the legislative power of the state is vested in the Florida legislature and includes the power to create, abolish, and control local governmental entities. Now, this is very counterintuitive because when you live in a city, for example, it looks like the city has all this power. It's this structure that makes it appear that the city has all this power. I've taught Florida constitutional law in law schools throughout my career. And one of the questions I remember asking on a final exam is, if you were representing a citizen in a city that the legislature had abolished by act, what would your legal recourse be in court? And the students frequently, despite having studied the Florida Constitution, would say and answer, well, I'd go into court and make this argument and this argument and this argument. There is no argument that you can make, because under the Florida Constitution, the power is vested in the legislature, and they can create, abolish, and control local government, any local governmental entity. As Mr. Langley just explained, the legislature did not give the Reedy Creek Improvement District authority to adopt a development agreement within the cities within the district. That composes about 85% of the land within the district. They did not have that authority, and because they didn't, when they purported to do so without the action of the cities, as Mr. Langley just explained, they were acting without authority. And for that reason, the development agreement is invalid, void ab initio. And I want to point out that each of these legal arguments are cumulative. They each stand on their own. You do what a responsible lawyer does, and you make every argument that is legally available and point them out to your client. But for any one of these reasons, the development agreement and the restrictive covenants are invalid. The second category, next slide, of illegalities is action attempted without following legally required procedures. We walked through this last week with the most glaring notice defect with respect to the development agreement that rendered the Sunshine Meeting required by Florida law a facade. Last week, David walked through another procedural defect that you will see laid out in paragraphs 10 through 12 of the findings you're considering. Dan just walked you through the multiple notice and other procedural errors that render the 2022 comp plan amendment attempted to be adopted by the Disney-controlled Reedy Creek Board and councils of the cities of Bay Lake and Lake Buena Vista, null and void. Because those were ineffective, and here's the legal effect on the development agreement, as Dan just explained, without a comprehensive plan and the ordinances pursuant to which the law requires a development agreement to be enacted, you can't have the authority to enact the development agreement. That's laid out in paragraphs 22 through 40 of the findings that you're considering. Next slide. Third and finally, the old board's actions, though the board had the general authority to act, violated the Constitution and other substantive laws in ways that were laid out last week. And I won't go through all of those again, but each of those are covered in the findings that you're considering. The result is that the development agreement and restrictive covenants were of no legal effect for many legal reasons, and I respectfully recommend that this board declare them null and void, along with the 2022 Comprehensive Plan Amendment and associated amendments to the Land Development Regulations. And I do so because that is simply the legal reality. Thank you very much.
Thank you, Justice Lawson. Do my fellow board members have any comments regarding these presentations?
Mr. Chair, I just want to thank our legal team, Mr. Langley, Mr. Lawson, and your teams. You've done a tremendous amount of work in a very short period of time, very complicated subject matter, and really have put together a very comprehensive and very transparent picture of what transpired. And as we have discussed ad nauseum, going back to the March 29th meeting, just the voluminous issues and infirmities that that belie these documents. I did want to just ask you, and I think the agenda item we have, 8.1, is to declare the development agreement and the declaration of restrictive covenants void ab initio and adopt the legislative findings of fact outlined in the agenda item. Do we need to have a future agenda item about the 2032 comp plan and recognizing the 2020 comp plan as the operative comp plan? Because I do think we need to probably address that as well, because obviously our staff, our planning staff, our building department, our stakeholders need certainty on what the operative comprehensive plan is.
It's a good question. That would be my recommendation, that we would need to, or we should bring back something for further action with respect to that. The motion, as reflected, is requesting adoption of the findings of fact, the legislative findings at this time, and direct the staff in the district to act accordingly. But I would like an opportunity to consider that additionally and to bring back a future item on that particular issue. But the legislative findings do include findings that make it clear that the comprehensive plan amendment was not properly adopted, nor was the land development regulations. So I would also ask that the board direct the district and the staff to act accordingly. So, but we may need to clean up the ordinances on the books. But, you know, the official, and I was pulling it up, I'm sorry I didn't pop this up earlier, but this is, for example, this is the official signed ordinance resolution for the comprehensive plan amendment of the district in the official record book. There's no, again, there's no attachment. So, you know, it's not adopting anything, but we did transmit to DEO something that stated that we did. So it would be good to clean up the record. So I would like to do that in a future process and not today.
Absolutely, yes. I think that's necessary. And unfortunately for me, I spent many, many hours reading those 390 pages of the comp plan that apparently does not exist. So I will not get those hours back, but that's okay.
Any other comments from my fellow board members? I have a few comments. You know, you just heard a lot of detail about ordinances and plans and what wasn't an exhibit and what wasn't attached. And let me just put this in perspective in a simple way. We didn't learn about these agreements that our lawyers tell us are unlawful until we had been serving on this board for about 6 weeks. And what you need to know, because some of the comments from some of our small businesses is that you said you wished that we would work together with Disney. So let me give you a little perspective on that. Shortly before, the day of that we were appointed, before we were officially appointed, each member of this board met with a vice president of Disney. And that vice president of Disney said, we want to work with the new board. We want to make this work for everybody. And so we thought we were off to a good start. They're a big part of this park. They're a big part of the district. We were all delighted. In fact, each of us committed that we would meet individually with the leadership of Disney to figure out how we could work together for the benefit of Disney and for the benefit of all the small businesses that came here today and spoke with us. And so we thought we were off to a good start. And then 6 weeks or 5 weeks later, I get a call from our general counsel at 10:15 on a Friday night, and he said, "You're not going to believe what I found." I said, "What's that?" He says, "In asking for a bunch of documents, we turned up some agreements between the old board and Disney that effectively say that the new board can't do what the Florida legislature and Florida's governor say you can do." And they did this at the 11th hour. Think about this. This whole dispute between the governor and Disney was going on for 2 years. And they decided that a couple of weeks before this board takes action, that they're going to tell the Florida legislature and the governor and this board that they can't act according to Florida state law. So to respond to our small businesses, that's not working together, okay? And so you understand that perspective. Disney picked the fight with this board. We were not looking out for a fight. We had agreed to meet with the leadership of Disney to figure out how we could work together. And then with respect to what you heard here, because there was a lot of detail and a lot of things that are complicated, but bottom line, what our lawyers have told us is factually and legally, what they created is an absolute legal mess. It will not work, okay? But nevertheless, and this is going to answer some more questions from our small business owners, we had to hire lawyers to first evaluate these 11th hour agreements. And they have evaluated them, and that's going to cost us money, okay? And because that is going to cost us money, then we're going to have to raise taxes to pay for that, okay? And some of the other things that I want to address from the small business owners, because we hear you loud and clear, is there were a lot of functions that this board did that were not according to Florida law. They were not functioning under best practices, and we've got to bring those transparency and accountability for the benefit of all of you and to be in compliance with Florida law. And because that wasn't being done by the old board, and this board is lawfully mandated to do it, it is going to cost us some money. And so, but one of the things that Disney could have nipped in the bud is not created this mess of legal documents that is now causing us, the district, to incur unnecessary expenses. And so that's all I have on this point. The next item.
Mr. Chair, do we need a motion to approve agenda item 8.1?
I'm going to get there.
Yeah, okay, sorry.
So the next item dovetails into Justice Lawson's presentation, and it's item 8.1, and I don't think we need any further discussion on this, do we, Mr. Langley?
No, it'd be appropriate to make a motion at this time.
Okay, I'll make the motion. I'll make a motion to approve the legislative findings of the Central Florida Tourism Oversight District Board of Supervisors relating to the February 8, 2023 Development Agreement and Declaration of Restrictive Covenants, and direct the district and its staff to act accordingly. Is there a second?
Second.
Any discussion? All in favor, say aye.
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 Any opposed? Let the record reflect that it passes unanimously. Thank you very much, Mr. Langley, for your presentation, and thank you very much, Justice Lawson. We'll now get to the public hearing part of our agenda. First, 9.1, and I would ask Mr. Langley to address that.
Okay. Resolution number 639, final reading. A resolution of the Central Florida Tourism Oversight District amending Article 6, Chapter 6-90, and Article 7, Chapter 7-20, and Chapter 7-30 of the RCID Land Development Regulations, providing for codification, suburbility conflicts, and an effective date. This is the second reading. I did a report at the first reading and public hearing. Unless there are any questions, I don't have anything further to add. This is a public hearing, so I would ask if you would, anyone who wants to speak could at this time on this particular item.
So are there any public comments? Hearing none?
It'd be appropriate to make a motion at this time.
Yeah, I think we need a motion for second reading. Is that correct, Mr. Langley?
This is the final reading. We had the first
Okay.
reading at the last meeting.
Is there a motion?
Yeah, I move to adopt Resolution 639.
Second.
Any discussion? All in favor, say aye.
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 Any opposition? Passes unanimously. We'll move to public hearing item 9.2. Mr. Langley?
Resolution number 640, a resolution of the Board of Supervisors of the Central Florida Tourism Oversight District adopting regulations prohibiting COVID-19 restrictions and mandates by businesses within the district upon their customers or patrons, and prohibiting COVID-19 restrictions and mandates regarding the services and operations of the Central Florida Tourism Oversight District, providing for severability conflicts and an effective date. Previewed this at the last meeting as well. This resolution would prohibit a business entity operating in the district from requiring its patrons or customers who want to obtain access to goods or services or that establishment from having to provide documentation certifying that the customer or patron has a COVID vaccination or post-infection recovery and doesn't allow imposition of any COVID testing mandate to gain access to those businesses' services. Also, that further, it puts in one place also the COVID policies that you adopted in the board rules. That would be just good for the records to have it all in one location, related things, so it further does that. This resolution, the provisions are consistent with current statutes and the pending legislation on this issue.
And I know this is an item that the vice chair has put on the agenda, and so I'd give him the floor now if he'd like to speak to it.
Thank you, Mr. Chair. I know I want to credit Supervisor Ziegler, who I think also brought this up earlier in the year, and just say that my understanding is consistent with Mr. Langley's. This is a resolution that's consistent with what will be state law, and also I think consistent with what we saw in Washington this month, where the COVID pandemic was, or the emergency was officially declared no longer to be in effect. And I would urge the board to adopt this so we can make clear for everyone in the district that this will not be a concern of theirs moving forward.
Any other comments?
Yeah, I have a couple comments. So, I think it's interesting, kind of dovetailing into the comments that were made by the public, and I want to make sure I reiterate Chair Garcia's statements that I do take those very seriously and hear what you're saying. I think a lot of the comments were highlighted of that, how grateful they were to operate in the state of Florida in a time that was unprecedented across the country. But as more information became aware, under the governor's leadership, we were able to continue and pursue open business and opportunities. I'm also a school board member in Sarasota County, Florida. I can tell you, as a policymaker, they were unprecedented moments sitting there trying to evaluate that. But as more and more information became aware, we were able to open up our schools in the state of Florida where other schools were not able to be done, just like the business components. But what was challenging is that when you think about certain components about, if you think about COVID restrictions, that has an impact on the thrivingness of your business. I've heard from many people, sadly, who had to actually leave their jobs in this area that they loved because of the overzealous aspects and requirements of certain corporations, including Disney. And then there were heartbreaking stories, and I do recall a reporter kind of taking a jab of saying that this is a political statement. No, this is protecting businesses to operate with the freedom of those liberties and components. I think that I can't underscore that enough, and I think it is important, as Chair Garcia highlighted, this kind of legal mess that we found ourselves in. I, as a Floridian, and I know the governor and representing the governor in this capacity, takes that very seriously to ensure that we have a thriving economy, a thriving tourism economy, but also to support small businesses and also to support free and individual liberties. And so I think it underscores that ability to support our businesses so that they can be successful. We know what the climate is and what's supportive of in the state of Florida. I think also not alienating your customer base is a really important aspect. If you think about, as your tenant, you're a tenant of a landlord that potentially has run that risk, and I hope that that's not the case. And I think, as I've mentioned and it was said here, our goal is to work hand in hand so that we can support the businesses in the state of Florida and support the thriving tourism industry that is a point of pride in Florida, and also to help make sure people enjoy coming and visiting, but also our Floridians as well. And I think that's a role that this board will take very seriously and not minimize that. But I do want to highlight that there are steps that have been taken, unfortunately, that have put us in this place. But my commitment, and I don't want to speak for my board members, but based on all the actions up here, is to work and have an open ear. I think we've been able to solve some pretty historically long issues that didn't necessarily take us too much time. I know that we've had great work by Mr. Langley and other board members, but I want to, again, reiterate my commitment to the members of this community, but also of the state, small businesses as well, to ensure that we aren't alienating anyone, that we see them thrive. I would be remiss to say that there are certain corporations that I think completely alienated their customer base, and we see the devastating impacts on that. And so that's not what my hope is. I hope that, of course, each company is going to make those own decisions, but as a board and oversight in the district, we're going to do whatever we can to see those operations thrive. So I just wanted to reiterate that commitment. Thank you.
Thank you for their comments. Any other comments from my fellow board members?
This is a public hearing, so we should open it up for any comments at this time.
Yes, ma'am. Did you want to speak?
Correct me if I'm wrong, but I think one of the foundations of being a Republican is that we try not to be too heavy-handed on businesses. That small businesses and other businesses can make decisions and operate without fear of heavy-handed legislation. Restricting a business from making a decision about COVID-19 may seem like it's casual to you, but people died. A lot of people died. And I think this area took responsibility in ensuring what they could do by losing billions of dollars, by the way, as a corporation, to protect people. And when they returned people to business, they did so in what they felt was a safe manner. People weren't laid off because they were wearing masks. People were laid off because people stopped flying into our area. Our airport suddenly were a ghost town. The tourism, which we are known for and which we respect and which we thrive on, people weren't coming. People were afraid. People were dying. People were not supposed to gather in large groups. I don't know where you guys were, but I will say that for us, and I hope for you, that you took some precautions for your families, for your schools. And as far as our schools operating, they operated with kids and computers. And yes, it was difficult. The teacher had some inside, some on computers, remote learning. It was very, very difficult for the teachers. But I will say that to say, you're going to sit here as a board appointed by our governor and tell businesses what to do and how to do it on COVID-19, it's a very sad day. It's very, very sad. This feud and whatever it is that Governor DeSantis is using as political step-off for presidency, it's not going well for you. We're the laughingstock. Let people do what they do. Don't come in with your lawyers from Tallahassee and turn our world upside down. I'm sorry that you're doing so, and I'm sorry that you see this as so important or that they made mistakes. Sure, boards make mistakes. I'm sure you have too in your businesses. But whatever your intention is for this pass, and I know it'll pass unanimously, why bother speaking? I speak because I care. And I think to come in and tell businesses how to run these people are afraid. These people own businesses, they have employees that have bought homes here, devoted their lives to this area, and you're turning it upside down by your power. And I just think it's a very sad day for the state of Florida. Thank you.
Thank you for your comments. Are there any other public comments? And do we need a motion?
Yes.
Is there a motion?
I move to approve Resolution 640.
Second?
Second.
Any discussion? All in favor, say aye.
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 Anyone opposed? Passes unanimously. Okay, next is unfinished business. And this board will be hiring a new administrator. And Mr. Classy has expressed an interest in remaining on in another capacity. And the vice chair has been discussing this with Mr. Classy and negotiating it, and so I would ask him to update the board on the status of that.
Yes, Mr. Chair, the update I have for the board is that we probably need to bring this back up at the next meeting. So I would ask that the agenda item be carried over until that meeting. We're having very productive discussions. We're quite close to having a final agreement in place, but we're not quite there at this moment, and I'd like to continue it on to the next agenda, if it's okay with the chair and the board.
Okay, thank you for that report. Yes, sir.
Mr. Chair, I just want to make a comment on the draft district administrator job description, if I might. If this is appropriate time, or is that?
We're going to get to that.
Okay.
Okay.
Thank you.
Any other comments with respect to the vice chair's report on Mr. Classy's new arrangement? Okay, the other thing that I need to report to my fellow board members is that as a result of the board hiring a new administrator, I have received several phone calls, referrals, some resumes, and I am pleased to report that we received a resume from a candidate who is interested in that position, an outstanding candidate. If you know anything about public policy in Florida, you're familiar with this candidate. He's a man who is dedicated to public service and has done, I think, more than anybody I know to help the underserved in the state of Florida. He is bright. He is of the highest character. He is hardworking, and he has exceptional leadership qualities. And his name is Glenn Gilzine. And what I'd like to ask from my board is that you meet with Mr. Gilzine before our next board meeting. I'd like for you to meet with him individually, ask him whatever questions, and hopefully you will come to the same conclusion that I have in terms of his qualifications and what a great opportunity this is for the district. And in the meantime, of course, subject to your approval, I will, with your authority, negotiate with Mr. Gilzine an employment contract, and my goal is to have such a contract presented to us at our next meeting.
Mr. Chair, I think that's a good idea, and if you'd like a motion, I can present one adopting that point, or you can make a motion, and I'd be glad to second it.
I'll take your motion.
We'll move that you, as the chair, have the authority of the board to enter into discussions with Mr. Gilzine, and also that I believe the rest of us will thereafter meet with him, either virtually or in person, to discuss his interest in the board and the district.
Second.
Any further discussion? All in favor, say aye.
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 Any opposed? Passes unanimously. Okay, Supervisor Onyx, let's get to the next.
Well, yeah, I was just going to mention on the district administrator position, not a requirement, but a preference that I would have would be a master's level degree in one of the associated fields, and I noticed that Mr. Gilzine does have a master's degree, so that's fantastic. And I did just want to echo, I've known Glenn for many years. He was a faithful and excellent school board member in Pinellas County, and I know he's established himself as an excellent, outstanding not-for-profit leader here as a CEO, and has been recognized as CEO of the Year by Orlando Business Journal. So I'm very excited to meet with you again, Glenn, and we'll see where we go from here. But I thank you for your interest. Appreciate it.
If I may, well, I was excited to see this familiar name pop up, and I could not say anything. I would echo what was just stated. I think that, especially even when we had members of the public come forward, this is a gentleman that I know works deeply with everyone to see that we succeed. So I could not be more excited about this opportunity to work with him.
Any other comments? Mr. Gilzine is here, and I'd ask him to just stand up, and so everybody can recognize him. And we really look forward to getting to know you better and working with you. And thank you for attending our meeting today. Is there any other discussion on the items on the unfinished business portion of the agenda? Hearing none, Is there any board discussion before we go into a shade meeting?
I just wanted to follow up as far as making sure the business, as was mentioned on the comp plan, what that next step is. At the next board meeting, is that something that needs some additional work? I think that was a well-stated point.
What I'd like to do is I'd like to have discussions with DEO of what they're looking for as far as an action item from us to correct the record, make it straight, because the district did transmit something that purported to be a comp plan to the state. So I'd like to get some commentary from the state on that, and then report at the next meeting or bring back an action item.
Very good.
Mr. Chair, I'm sorry.
Go ahead.
This isn't extremely pressing, but I did have a list of things before we uncovered the unpleasant surprise of the development agreement and the deed restrictions. And on that list there are some advisory boards. I know that we have done away with the planning board and have addressed that, but there are two other advisory boards. There is a board of appeal, which my understanding was a board that was to hear any site plan or permitting appeals from a staff level. So disputes with our staff would go to that board. I think we should probably have that authority as opposed to that board. So I'd like to ask Mr. Langley and you to maybe look at that over the next month or so and do that. And then the other one is the pollution control board, which I don't really know a ton about. I'm not as concerned about it, but I think we need to know more about it and evaluate that as well. So those two boards are still in existence, and I do think we need to look at those and understand them and consider any kind of action we need to take given the new structure of the new act.
So I'll take that as you're wanting to put those two items on the next agenda and get a report to you on that?
That would be great.
Can we do that, Mr. Langley?
Yes, we can get a report. If we need to make additional changes to the way those boards are structured, and may need one more meeting to have a resolution advertised.
Thank you for your insight on that, Supervisor Ernst. Any other comments before we go into a shade meeting?
Mr. Chair, one more comment, which is more of a request to reiterate from the last meeting, which I want to thank our general counsel who's working overtime, but we would like to see a proposal to have a means and a process for any lobbyists or people that represent other stakeholders in the district. And I think we could maybe consider to add that into our policies and procedures as a board. I want to make sure that folks know how to get a hold of us when they want to comment to the board so that they can have that access that I know many of them expressed today that they're interested in. And it's also helpful from our perspective so we know who's contacting us. We get a lot of calls and emails, and we want to know who the people are that are reaching out to us and those that are trying to discuss issues that might be important to the stakeholders. So I think that policy might further that goal and that interest as well.
Yeah, I actually have a draft that one of my associates provided to me. I just, haven't got to review it. So if I can review it this week and turn around, if it's not too late to get an ad posted this weekend, maybe we could take action on it at the next board meeting.
And I know you've been working very hard, and we're all grateful. Thank you.
Thank you.
Nothing else, Mr. Chair.
Anything else? The only thing I guess I really need to say is about our general counsel. I don't think a day has gone by that I have not spoken with him since we've been appointed. And he and his partner have been just fantastic. And, I am a lawyer. I haven't practiced law a long time, but I've dealt with a lot of lawyers. And there's no question that there's a lot of smart lawyers. But being able to find a lawyer that is smart, committed, and has really good judgment is not the easiest thing. And I'm really grateful for the judgment that our general counsel is exercised throughout this process. And then the amount of work that he's put into it. I mean, he calls me at 10 o'clock at night on the weekends. I get 4 a.m. emails from him, and he is very dedicated to the cause of the district. And I just want to thank you on behalf of the board for all your good and hard work. So now we'll recess. We'll go into a shade meeting, and we'll come back. There's nothing left on the agenda. When we come back, we will just merely adjourn.
Diverticulitis? Oh, no, that's painful.
Oh, my deadhead.
That is not good.
He's feeling better, he was just
That's
afraid.
good.
Yeah,
He was just
flare-ups.
afraid he would become.
Yeah, that is
Yeah.
not
Gonna bring a parka next time.
Okay, we will stand adjourned.
Thank you, Mr. Chair.
Thank you. Thank you.
Likewise, oh, you're staying here, huh?
Yeah, I was here, yeah.